Welcome to the Ansons Podcast. Today we are going to be discussing family law. We're going to be taking you through the divorce, which we split into 3 boxes. First of all, the divorce proceedings themselves. Secondly, the financial aspects. And thirdly, children. Welcome to the Ansons Podcast. Doing these podcasts for a few weeks now, and the demand, finally given way to the demand and invited Mike Vale, our well-established family lawyer known across the Midlands, to the podcast today to discuss family law. Welcome, Mike.
Thank you very much. Good day.
We were having a discussion on the way over today about divorce, and perhaps just generally, until you go through it, the general public's lack of understanding of quite what is involved. I'm not planning to get one if my wife is watching, but what's involved in a divorce?
Well, once consulted by a client who comes in with a matrimonial problem, inevitably the D word, divorce, crops up. What I like to do in the first instance is to ask that client whether or not we really have to do this. In other words, are we really talking divorce? My approach is to find out what the position is in the marriage, and if the conclusion of the client is that that marriage has broken down irretrievably, I will discuss the various elements of the divorce with him or her. And those elements are basically threefold. Firstly, the divorce itself, the dissolution of the marriage. Secondly, financial and property matters, and not least of all, the children. And I put them in 3 boxes for the client. Box number 1, the divorce itself. Box number 2, financial and property matters. And box number 3, the issues relating to the children. And I unpackage all of the boxes and go through what's involved.
But I think that's an important first point. You don't see yourself as a divorce pusher.
No. Absolutely not. I mean, divorce inevitably is a stressful business. Whether people want a divorce or not, it is stressful. And although the divorce itself isn't all that expensive in this day and age because the process is quite straightforward, but the other issues...
The other boxes.
the other 2 boxes can lead to not only immense stress, but great cost. And it's important to establish the reality of it before the roller coaster starts. Do we really have to do it?
Well, just wanted to talk about actually those 3 boxes and to deal firstly with the divorce, which I presume is the procedural element, is it of?
The divorce is the umbrella under which you would place issues relating to financial and property matters. Those are the 2 boxes. Children proceedings are entirely separate. But in terms of the first box, if you want to ask me about that, the process in divorce is very straightforward. Firstly, as a matter of law, as of April 2022, the sole basis for divorce is that a marriage has broken down irretrievably. And that's a unilateral point of view. So if a spouse says, my marriage has broken down irretrievably, it has.
Is that before that? At one point, did you notionally have to prove bad behaviour or adultery or something along those lines?
Pre-April 2022, the sole ground for divorce was still that a marriage had broken down irretrievably, but it had to be demonstrated. You had to demonstrate that irretrievable breakdown by proving one of 5 facts. And 2 of those facts are, well, 3 of them actually are fault-based. Fact number 1, adultery. 2, unreasonable behaviour. 3, desertion for a period of 2 years. 4, you could have a divorce by consent, but you had to be separated for 2 years. And the 5th fact was you had to be separated for 5 years if none of the others applied. The most common basis for divorce was unreasonable behaviour. Now, if you're trying to resolve matters, the other matters, amicably and in a conciliatory way, it's not a great start to start alleging all sorts of...
Well, it's a blame game, right?
It's a blame game. It's a blame game.
Or it used to be a blame game, even though it probably didn't have too much of a bearing on whether or not you did get divorced, but your starting shot was to, in a court document, make a number of allegations.
Absolutely right, and handled badly. Not a great start to a case to deal with the other issues. But, however, that's all changed. As I said, it's now simply...
Did judges ever, in recent years prior to that change, did judges ever actually reject a divorce petition on the basis that you didn't make out the grounds?
They did. I mean, there's a very well-known case. It's been reported, so I can name names. Owen versus Owen, a couple who lived in Worcestershire. And the wife applied for divorce on the basis that her husband's behaviour had been unreasonable. He defended it. He chose to defend it, as was his right.
Go on, what had he done? Was he a bad snorer?
Well, he wasn't that bad because he hadn't behaved unreasonably, and that was a subjective test. The judge held that his behaviour wasn't that bad. I don't quite know what the grounds were, but they couldn't have been terribly serious.
It couldn't have been serious enough to, I'm thinking of all of the things that my wife would sort of hold against me.
Well, I used to say, before you talk about your wife and your own sins, Martin, I always used to say to clients that, and it's not a proud boast, but anybody who'd been married for more than a year, and you had to be married for a year before you could apply for divorce, by the way, you could scratch together a so-called unreasonable behaviour petition. It's just the vicissitudes of life, really, that people get on each other's nerves. But that Owen case really brought it home that divorce isn't there just for the asking. And there'd been a lot of lobbying for a long time to change the law so that you took blame out of it altogether.
Well, I mean, so that was a positive step in your view. So now it is just you make the assertion. It's based on your own one person's subjective view. It's not going to be challenged by the court.
It's not going to be challenged by the court, and indeed, as a matter of law, you can't defend it. The only basis for defending a divorce these days would be if there was a jurisdictional issue. But whether the opposite spouse likes it or not, he or she can be divorced on the basis of irretrievable breakdown.
Whether it happens to you in some respects, whether you like it,
it's still necessary. Notwithstanding that, it's still necessary to handle it in a sensitive manner and have regard not just to your own client's feelings, but to the feelings of the other spouse, in particular if they are aggrieved at the prospect of being divorced.
So typically, client comes to see you and you've had that discussion and they have decided that they do need to proceed with the divorce. Does that actually, apologies for asking sort of relatively basic questions here, is the first step a letter written to that person, to that person's other half?
I'd like you to keep it simple. Yes, that's absolutely right. And you introduce yourself to the other party. You say, as it normally is the case, that you've been instructed, but your client wishes to deal with the matter on the most amicable basis possible and the most conciliatory basis possible, and that we as a firm at Ansons will do all that we can to foster that sort of climate.
And then, assuming there's some sort of positive response, they might go and see their own lawyer. The next stage is what, a court form? We hear about a divorce petition, although petitions sort of typically gather a load of signatures on a bit of paper, but a divorce petition is really a court form, right?
The language has changed. We had divorce petitions pre-April 2022.
Oh, right. So
it's now a divorce application, a much more neutral and more modern word.
Right.
And the application is quite straightforward. It's whereas the old divorce petitions ran into several pages sometimes, a divorce application simply states the basic facts. The date of marriage, names of the parties, and a statement that the marriage has broken down irretrievably. That application is filed with the court and served and hopefully acknowledged by the other party. Served,
of course, meaning sent to.
Correct.
Yeah, posted.
Well, email will do.
Okay, yeah. The courts have caught up with all of that sort of stuff these days.
Well now. Yeah.
And so that's served. They acknowledge it, and what is it then set down for a hearing, or does it not even do that these days?
As long as it's acknowledged, and as long as a period of 20 weeks has elapsed from when the application is made, you can apply for what's called a conditional divorce order. Conditional divorce order used to be called a decree nisi. But you can't have your conditional divorce order until a period of 20 weeks has elapsed. And during that 20-week period, you get on with boxes B and C.
And that's the yellow card of the divorce before the red card is coming.
I've never heard it put like that, but that's perfectly correct.
Yeah.
6 weeks, 6 clear weeks, in other words, 6 weeks in a day after the conditional divorce order, you can apply for the final divorce order, which we used to call a decree absolute, although often one doesn't apply for the final divorce order until financial and property matters have been resolved for various technical reasons.
Oh, so you can get it dealt with all under the same umbrella as you called, as you referred to it earlier. Yeah. Just in terms of the that conditional divorce, what does that mean legally?
It simply means that the court accepts that you've made out your case, that the marriage has broken down irretrievably, and that you can be divorced at some future
and apply
point.
for the future. So to get to that point, typically from filing the application, we're looking at what, 20 weeks?
20 weeks, 20 clear weeks.
And on this podcast, one of the themes has been a little bit, court system is creaking a little.
I'm afraid it is.
And in terms of, is that 20 weeks, that's the minimum period, is it? Or are the courts pretty good at getting the orders out?
You can only apply once 20 weeks has elapsed. You're then in the hands of the court as to how soon that conditional divorce order is granted. To be fair, it's pretty straightforward. It's all done through a court portal.
Right.
And really,
an online system, yeah.
It's an online system, and within a week or two after you make the application for the conditional divorce order, it comes through. It's granted.
Okay, that's positive.
And then you start ticking off how long is 6 weeks, and do you really want to apply for the final divorce order?
So at the beginning of the podcast, you discussed that one of the boxes, so that's the divorce element boxed off, and we know that now that isn't a blame game, that it's far more procedural than it used to be. However, there is a bit that can often be a bit more contentious coming, which is the box that you refer to it as a box, which is the financial aspect of that.
Yes.
And that is formally part of the divorce proceedings, is it?
Yeah. I mean, you start off dealing with financial and property matters from the outset, and the right way to approach that is for everyone to accept and understand that there has to be what lawyers are pleased to call full and frank financial disclosure. In other words, all the financial cards have to go on the table face up. Now, that can be a complicated process. It very often involves valuing a property or properties. It involves valuing a company. And so that's quite a long process, but you get on with it, and hopefully everybody plays the game and cooperates in putting the financial cards on the table face up. There is a standard form which family lawyers are used to referring to.
I've heard this one. What's it called?
It's a Form E, a financial statement.
And this is you write down all of your assets and...
Not only your assets, but all the circumstances of the case which you consider to be relevant. So you've got to deal with your financial numbers. You've got to give your best estimate of what those assets are worth. You have to produce 12 months' worth of bank statements. You have to produce documents related to the cash equivalent transfer value of your pension, and so on, so that there's a very full understanding of finances and other circumstances.
It's that part of the divorce that can often, it's one of the parts of the divorce that can get contentious, that can get where parties fall out. What are the typical disputes that need to be resolved as part of that? Is that just not disclosing what you're meant to disclose?
That is the main problem in many cases, a failure to disclose. I have to say sometimes people try to be clever, you have an asset. Here you are, Mike. I'll transfer this asset to you for £1, and when the coast is clear, you can transfer the £100,000 asset back to me. That won't work in any case.
No.
Because there's a piece of legislation called Section 37 of the Matrimonial Causes Act, which allows the court to reverse any dodgy transactions.
And in terms of if you feel like a party hasn't given full disclosure of, they've got, a couple of vintage sport cars, a couple of expensive luxury watches or whatever it might be, what would you do? You would then make a further application to the court on that issue? You
would do that, but before you can do that, the family procedure rules now require parties to attempt non-court dispute resolution.
Mediation,
arbitration, but ordinarily mediation. You send your client off to a mediator. The other party, where appropriate, is invited to engage in the mediation process. But if that looks like a dead duck from the outset, the mediator would issue a certificate enabling an application to be made to the court.
So actually you're virtually obliged to try something that isn't a judge making a decision.
You have to.
And the most normal version of that, most of the time, is a mediation.
It is.
And we're used to discussing that on this podcast. A mediation, typically we've got a third-party mediator, often a lawyer, but they don't have to be. And they typically don't make any decisions or judgments, but engage often in subtle diplomacy between the parties to see if they can reach agreement. Yeah. And if we can reach agreement, I mean, that's great, right? And
that's fantastic. I mean, the mediator will say that if the agreement is reached within mediation, the mediator will say, well, it's not binding. You should go and see your family lawyer, your divorce lawyer, if you will, and check it with them if they're happy with it. If they think it's reasonable, then go ahead. And of course, we strive to reach agreement.
So one of the things that I've heard you talking about or being engaged in is after a mediation, and let's say that hasn't been successful, you often have, now apologies if I'm going to get the name wrong about this, but is it an FDR hearing, which sounds to me a bit like a judge almost half acting as a mediator, half acting as a judge. What's the FDR?
Okay, once you issue your application, once the mediator's given you your certificate and you issue your application, the first court hearing, is an FDA.
Oh, okay. What does that stand for?
It's a first directions appointment.
Oh.
And it's a kind of judicial housekeeping. So you go and see the judge and you say to the judge, well, the judge will say, what's the position in this case? Well, sir or madam, as the case may be, we've exchanged Forms E. We need directions to deal with other aspects of the case, directions as to valuations and that sort of thing.
Okay.
Ultimately, and almost certainly, the judge will make the required directions to move the matter onto the FDR, the financial.
Oh, so there is an FDR. Okay. I was getting my letters wrong.
Well, the FDR, Financial Dispute Resolution Appointment, is a very serious hearing. I always think of it as a kind of coercive judicial mediation. In other words, there's a lot of negotiation, a lot of discussion at an FDR, and sometimes a certain amount of arm twisting. But ultimately, a good judge will, if he or she feels capable of doing so, able to do so based on what they hear, will give an indication as to what that judge would do if the matter progressed to a final hearing.
On that specific issue, typically. Because there'll normally be a list of issues that remain in dispute. You go to the FDR, and that could be the valuation of the house or who's going to keep the house.
The FDR is an off-the-record, without prejudice, if you like, pretend final hearing where the judge doesn't hear the evidence but hears submissions and is told what the position is in the case.
And he gives a bit of an indication.
And gives an indication and says, well, if I were the judge, if this case came before me at a final hearing, I think, Mr. Vale, your client's asking for a bit too much. Mr. Smith, your client, needs to be a little more flexible. Go and talk some more outside. Go and see if you can agree this, because the judge will say kindly to the clients, like a Dutch uncle, if you can't agree this today, this case will have to go off to another judge who may have a different view to me. Neither of you may be satisfied by the outcome. Whereas if you can reach agreement today, you may not be terribly happy with it, but at least you've taken control of your own case and you've settled it on terms which you can live with. So, otherwise, you go to a final hearing and it will cost you a considerable amount in legal fees.
So the final hearing is, in effect, the divorce trial or the financial divorce trial.
It is just that.
Is it possible at the FDR that you can tick certain of the issues off and then only go to the trial or the final hearing on the value of the house?
Well, certainly, yes. I mean, it's possible to narrow the issues and reach agreement on certain aspects and then deal with the rest of it. How long would an FDR, I assume, is a one-day event for the most part, is it? Is that right? Well, it's usually set down for 2 or 3 hours, but the lawyers tend to hang around for as long as it takes. And if there's any chance of settlement, I've had cases which have run past midnight, where we've been to court, we've been kicked out of the court building, we've gone to either the solicitor's office or counsel's chambers and carried on the discussions and reached an agreement or not, as the case may be. So you should make a lot of effort to settle these matters at FDR, because that's good for the clients.
And is there any kind of rule of thumb in that regard? I mean, how many cases do settle at the
vast majority?
Yeah,
the vast majority. And courts will, if thought appropriate, will adjourn the FDR for a further FDR on the basis that it's
worthwhile.
It's worthwhile, and it does keep matters more civilised, particularly where we're having to discuss not only the financial issues but the issues which I mentioned at box 3, the children.
We'll come on to the children shortly. The trial. How long will a trial last in a financial divorce proceedings?
Well, the trials I've had recently have lasted up to 5 days. 3 days, 1 day. It depends. It depends very much as to whether or not there's some serious cross-examination. I mean, take the case we discussed a little earlier, where, let's call him the husband, because it very much is trying to conceal assets. We would want to cross-examine that husband, and we would want to put to him.
So that's a barrister asking questions to determine the true.
At that stage, we probably would use the services of a barrister. Not always, but very often we do. We all know the difference between barristers and solicitors, I'm sure.
Well, yeah, the principal difference being that barristers are full-time and focused specialist advocates.
That's exactly right.
Who specialise in presenting cases at court,
Precisely.
as opposed to a solicitor who can be an advocate, but more typically runs the day-to-day aspects of the case.
It's probably a very bad analogy, but it's one which people would understand. When I try to explain it to clients, I compare it to your GP and your consultant.
Yes.
Me being the GP,
a
gatherer of information and detail, but when it comes to the operation, we'll get the surgeon.
Well, I wouldn't want you performing open heart surgery on me when that becomes necessary in due course.
Well, I'm sure I could find one, Martin, but maybe that's debatable.
Yeah, no, fair enough. So, okay, we've dealt with that. I want to touch upon something in relation to the finances. The prenup. Now, what is a prenup, and are they enforceable?
A prenup is a document which sets out what the parties wish to do in the event that they should uncouple. There are various elements which have to exist for the prenup to have any chance of standing up in front of a judge. First of all, there has to be disclosure within the agreement, financial disclosure. There has to be a complete absence of duress.
Yeah, no coercion from either side.
Undue pressure. It has to be completely arm's length, so both parties should have the benefit of independent legal advice and so on. It also has to be fair. Now, of course, fairness, like beauty, is in the eye of the beholder.
Yeah.
So the legal advisors must strive to make that agreement fair, because you ask whether or not they are enforceable. In other words, are they any good? They are certainly a lot of good if they are properly reached at.
Yeah.
Courts do hold parties to their agreement unless there's good reason not to. For example, getting back to non-disclosure of assets within the agreement, if it's manifestly unfair, and also with a prenup, you do have to build in stages for review. So if children come along, if the parties haven't got children at the time they enter into the agreement, and children come along which
will need to be provided for financially.
Provided for. So you build in review clauses to prenups, but they are worth it because it gives an idea as to what the parties' intentions were, obviously, and if fair, if reasonable, court will hold them to that agreement.
And in effect can presumably have a big impact on the negotiations between the parties to financial divorce proceedings, as well as ultimately the judge making a decision if he's forced to make that decision.
Those agreements are a factor in the case. If there's a dispute, if a party says, okay, well, I entered into that prenup, but I don't think I should be held to it for various reasons, you have to plead your case. You have to confirm that there was an agreement, and you have to give reasons why one party should be held to it and why the other party shouldn't. It's definite factor in the case, definitely worth doing, providing it's properly done.
No, fine. So we would encourage.
We do, and in fact, they have become increasingly very popular. If that's the right word.
A significant part of your time is involved in advising on both sides of those.
Absolutely, not only prenuptial agreements but also postnuptial agreements.
Okay, go on. What's one of those?
Okay, well,
I get that post is afterwards, by the way.
Well,
but
you probably wonder why people do it. What happens is that, in cases of considerable wealth, clients look for a belt and braces agreement. So you'll have the prenuptial agreement, and you'll have it confirmed by a postnuptial agreement. Some might think that's
immediately after the marriage.
No, you leave it for a year or two,
okay,
perhaps 12 months, just to reinforce the position.
Okay,
upon marriage.
Fair enough. It doesn't sound particularly romantic.
It isn't, but neither is divorce.
No, fair enough.
Neither is divorce. Going to court 3 or 4 times to fight over finances. There's nothing romantic about that, and it certainly doesn't do your bank balance any good.
Cost of divorce proceedings, the financial aspect. Well, let's deal with both parts of that. The divorce itself. What can a client typically be looking at paying?
When you issue a divorce application nowadays, there's a court fee of £593 to pay, and then you have, if you're instructing a solicitor, you don't have to because it's online and a lot of people can handle it themselves. Many people like to instruct a solicitor because they prefer the comfort, I suppose, of being guided. Typically that may cost £600, £700 plus VAT. The work is relatively straightforward. With regard to financial and property,
this is the how long is a piece of string, right, and how contentious it is.
It is, and I'm afraid if financial and property proceedings are contested, fees will run into several thousands of pounds, and there's no gilding the lily on that.
No.
I had a case fairly recently. It was a 3-day trial. So
in other words, they'd mediated. They'd gone through the FDR, they'd gone through the whole process, financial disclosure, everything.
Went through all that.
Yeah.
And the legal costs are frightening. The cost in that case were £50,000 or thereabouts, to include disbursements, that's to say court fees.
Disbursements, and we're trying to get rid of the legal jargon here. So the disbursements is typically things like court fees and the barrister's fees.
Barrister's fees, the cost of valuers, the cost of forensic accountants. I mean, if, just with regard to that, if there's a company and, say, both spouses are shareholders in the company, those shares would need to be valued. We'd need to decide who should have the shares, what the tax implications.
The basis of the valuation.
The basis of the valuation, yeah.
This often can be something that's contended, but I know from the area of law that I practice, is there a discount for minority and all of that sort of good issues?
All of that sort of stuff, and we work with forensic accountants in divorce cases, and we're guided by them as to the appropriate method of valuing that particular business.
I wanted to then move on to the third of the trilogy of boxes that we're describing today, which is the children act proceedings, and presumably that's separate from the divorce because, of course, people can have children and not be married. So I assume that the process is the same for married and non-married couples who have children together.
That's right, subject to one thing which I mentioned. It all comes before the family court, but it's a different set of proceedings. Those proceedings are under the Children Act. And the Children Act enshrined a principle called parental responsibility.
Okay.
Married couples who have children automatically have parental responsibility. I'll talk about the position in relation to unmarried couples in a moment. But they both have parental responsibility. And what that means in real terms is that they are meant to do their very best to try and agree the arrangements for their children. The basic arrangements for children are, of course, with which parent does the children or child have their main home. As regards the other parent, what time should that other parents spend with the child? There are then issues in relation to the children's education, religious upbringing, medical treatment, that they call specific issue orders made by a court. And there's something called a prohibited steps order. So if you discover that your spouse suddenly has a grand plan to go off to Australia with your children, you make an application for a prohibited steps order. But the
Stop that from happening if you disagree.
Yeah, absolutely, yes, absolutely. That's nightmare stuff.
Yeah, but in terms of the those processes, again, if somebody's a lot of the time couples will just. Couples who have broken up will just make their own arrangements and agree, and a lot of the time and that'll be fine, right?
Yes, absolutely. I mean, if they do agree those arrangements, then there is no need for a court order, no need for the court to intervene at all.
Or lawyers at all.
Or lawyers. I mean, it may well be that lawyers are involved initially in assisting the parties, advising them as to how matters should be dealt with.
And recorded.
But hopefully it's all agreed and people just get on with it.
So when will a person typically come to you? It's because there's some sort of fallout about how much contact there is with the child?
Yeah, well, parents consult solicitors to say that they want custody of their child.
We don't call it custody anymore. You told me this recently.
Since the Children Act 1989, which came
right.
into force in 1981, the word custody has been abolished because it was regarded as being too...
Well, it sounds like a prison cell,
yes,
doesn't it?
Yes, it does. You know, it's ownership of children. So we used... The terms were changed.
Yeah.
The terms have changed, and we now use much more neutral language, such as what parents think of as custody, we call live-with orders.
Yes. Oh, that's good.
You remember the word access?
I do, yeah. The SAT gone now as well.
That's gone. That went ages ago as well. Access is now time spent with.
Okay.
So the terminology has changed. It's all designed to try and keep the heat out of it, but unfortunately it doesn't always work.
Is there any rule of thumb or default position that a court's looking at this completely with fresh eyes every time they see it, or is there an assumption, for example, that the children will live with mother 5 days a week and father spends time with them at the weekends?
No such assumptions.
No.
It is what's in the best interest of the children. I mean, the circumstances are many and varied, aren't they? But it's what's in the best interest of the children and what the parents can offer the children.
Just in terms of the process on that sort of dispute, whereby one of the parents doesn't feel like they are getting to spend sufficient time with the child. In that circumstance, they would go and see a lawyer.
Yeah.
I'm imagining that there's a letter that would be written to the other side, the other half. So no, you couldn't call them the other half at the point at which they've separated, but the
other parent.
The other parent. A letter will be written. They'll often instruct their own solicitor. What happens there? We've got mediations, and is there an FDR and all that sort of stuff on the children's side of things?
Well, hopefully, once the initial letter has gone out and the other parent has consulted a solicitor, one of the solicitors will pick up the phone to say hello to their opponent and try and have a friendly chat about it and see really what the issues are.
Is the common ground, and can
we sort it out? Can we sort it out?
What if you can't reach agreement?
Well, if you can't reach agreement, then you refer to mediation again.
Yeah.
In the hope that the mediator can, solicitors are out of the room in family law mediation, so get the solicitors out of the room.
They don't even go to it, do they?
They don't. The solicitors are to blame for all the sins in case this happens. So it's the parents talking to the mediator to see if agreement is possible. Sometimes it is, sometimes it isn't. If it isn't, an application can be made to the court for the appropriate order.
Is there the equivalent of an FDR where the judge gives his view in children's?
Very much so, yeah.
Okay.
Yeah, and that involves the services of CAFCAS,
okay.
who we used to call the Court Welfare Service years ago, but they will talk to the parties and try and reach agreement. Lots of energy and effort will be put in to get the parties to agree. If no agreement is possible, if we've had the equivalent of the FDR, we'll have to have a final hearing.
CAFCAS sounds like ACAS, which I'm used to from employment law stuff. So I'm imagining who I spoke very favourably of ACAS, actually. And a couple of people from ACAS have said how pleased they were because they're often getting criticised by lawyers. Does CAFCAS do a good job?
Yes, they do. It's a very tough job. It's a difficult job. They're dealing with people with high emotions, but CAFCAS do a very good job. And if all else fails and we have to have a final hearing, CAFCAS produce a very detailed report telling the court about the background.
Hang on, I'm going to have a guess now as to what it stands for, right? So I'm using, I'm going to, CAS is bound to be Conciliatory Advisory Service.
Children and Family Court Advisory.
Hang on, I was going to guess that. You've just, that was the one interesting.
Sorry, Martin.
I was going to guess what that was. Children and what? Sorry, family.
I wanted to blurt it out in case I forgot it.
No, fair enough. So, and again then, if CAS, they've got involved, they can't impose a solution on the parents.
They can't, but what they can do, they can try and reach agreement, but ultimately what CAFCAS are required to do in the event of a dispute is to produce a report, and they will make recommendations in that report, which are highly persuasive. To
the judge. And then again, there will be a final hearing and a judge will make some decisions.
Correct.
And am I right to think, a bit like the financial proceedings, that the initial stages of this, you would give advice to a client and it's for you to provide some initial advice and perhaps write that first letter to the other side? Yeah. What sort of money are we talking there?
Again, if matters are fully contested, there's potential for 2-3 court hearings. You are talking not as much as in financial and property matters, because
it can run into the low tens though, quite easily.
It can.
Legal aid used to be quite well available and well used in family law. Unfortunately, it isn't these days.
It's all but gone. It's all gone. There is some legal aid available in cases of domestic abuse, but it's all but gone.
Yeah, so it's something that parents have to find themselves, and typically, unfortunately, won't be insured for, unlike other types of litigation.
Quite so. Yeah.
No, and I guess the advice what we would say there is then perhaps spending some money to get some initial advice, which might give you the parameters of what you should be trying to agree, and then trying to reach agreement with your co-parent is the way to go.
Absolutely, yeah, absolutely. I did just want to comment on the position of unmarried parents.
Yes,
mother will always have parental responsibility. Father does not automatically have parental responsibility, but it can be acquired. It can be acquired by entering into a parental responsibility agreement.
Okay.
Or if mother refuses to give that, father would have to make an application to the court for a parental responsibility order.
So that isn't just obtained automatically by being on the... I've heard people often say, are you on the birth certificate or not?
If you're on the birth certificate, you do have parental responsibility, yeah.
But you would still need the court order in terms of...
No, if you're on the birth certificate, you do have parental responsibility.
But if you're not, you will need to acquire it.
Correct.
And the only way to acquire it is either agreement or court order.
Correct, quite right.
Yeah. No, understood. Well, Mike, thank you for... the discussion today. That was really informative. And if you are facing, what would we say to people who are watching this video and want an initial discussion?
I would say to them, come along and I always call it a fireside chat, because I like to make it sound relaxed and informal.
Yeah.
When people consult lawyers, particularly about something so personal as a matrimonial problem, they are obviously extremely nervous. I do like to go out of my way to not make them nervous, to talk to them in a relatively down-to-earth manner, but try to help them through their difficulties. And I actually think that's the best part of the job, meeting people and piloting them through their particular problems. It's very rewarding.
And I think that people who are watching this video can get in touch with us via our website and book that initial appointment if they wish, and
Absolutely.
You'd be more than happy to
happy to see them at any of our offices.
Yeah, and talk through the situation, and it can be on just one part of those proceedings or the whole thing. A lot of the time, people are just wanting to know what's likely to happen.
They are. I always invite a client at first discussion, if they feel able to do so, to talk endlessly about what their situation is so that I can understand it. If they are reticent, then I will ask the questions and tease the information out of them, which I need to know to enable me to advise them. But I do like clients to feel free to tell me their story. It's very important. Even though I've said that the sole basis for marriage, for divorce rather, is that a marriage is broken down irretrievably, that doesn't mean people don't want to tell their story about what their marriage is like. And I encourage that because I think it's important to know my clients and know what's on their mind.
There is an area that falls almost between our two practice areas, me as a litigator, a disputes lawyer, and you as a family lawyer. And it is typically young, but they don't have to be, but cohabiting couples who purchase a house together. Now, if that couple, I guess the first point is divorce and financial divorce proceedings are not open to them, I assume, because they're not married.
They're not. The proceedings which are open to them are proceedings under Schedule 1 of the Children Act, 1989, and also what's known as talata.
So they don't need to go into box 1 because they don't need a divorce because there's no institution to end.
Right.
They potentially have got some financial assets to be resolved, and they potentially have Children's Act proceedings to, if they can't reach agreement in terms of, as we now know, time with children and those sorts of issues.
Yeah.
And as we've said, the children's proceedings, that's completely separate from divorce, strictly in the family court, but it's separate from divorce.
Yeah.
But the in terms of property and talata, we have got a bit of legislation, which is the Trustees of Land Appointment of Trustees Act. Can't remember which year it is. I bet you can't either, can you?
I could do if I really tried.
If we Googled it, not that we carry this knowledge around.
But it's a property dispute, isn't it? In a way which is very similar to couples who are divorcing, similar but not the same. I sometimes get consulted by clients in that situation, and what I again try to do is to see if an agreement can be reached.
Yeah.
If agreement can't be reached, then I pass it over to our dispute resolution department because the rules are entirely different. They're governed by the civil procedure rules, whereas family proceedings are governed by the family procedure rules. Yeah,
and I think in some respects we have got a default position there in that a couple who purchase a house together, the assumption will be that it's owned 50-50, both legally and beneficially by them.
And it very often is.
Yeah. And most of the time that's where it's going to end up, that the house, there will be an assumption actually that the house will get sold. So you ultimately would write a letter like you would do in the family proceedings, requesting that that they would like either to be bought out of their interest in the property, and if that can't occur, you would start possession proceedings. And actually, typically, a party is able to. The default assumption is the property is bought on a trust for sale. That the assumption is that people won't be locked into owning a house with somebody else forever.
Correct.
And a process will occur with mediation, typically with a final hearing if it can't be resolved, and ultimately a court will make an order both in terms of one, getting the property sold, and two, in relation to the split if there is anything to be said.
Precisely that.
And the trust and the talata proceedings do give the court a certain discretion when one party has made a much more significant contribution to the capital in the land, and that isn't just paying the mortgage. That would be something along the lines of they put forward the 25 grand deposit and the other partner didn't. There can be arguments that the court can fairly decide who gets what when that property is sold.
That's absolutely right. Of course, it can become complicated where there are children involved.
Yeah.
Under Schedule 1 of the Children Act, the court has various powers, including the power to settle a property on children during their minority.
Yeah, so when there are children involved, and to almost contradict my earlier point, a court can say until those children are of a certain age, that property can't be sold, and the
that does happen. Yeah. Schedule 1 of the Children Act is a very interesting piece of legislation, because not only does it deal with the issue we've just discussed, it deals with topping up children's maintenance, where the Child Maintenance Service has reached a maximum assessment.
That's the what are they called, those people? CSA, are they? Are they not called that anymore?
In the olden days, they were called the CSA, Martin, the Child Support Agency.
Yeah, I heard of them. They always used to joke about them on Have I Got News for You, but I guess it's not particularly a laughing matter if you're involved.
It isn't. It's they're now called the Child Maintenance Service.
Okay.
And it's an instrument of government which causes a huge amount of stress and difficulty.
But then that can tie into an unmarried couple who have got a property together and children together. Courts have got, outside of the normal matters that I would get involved in terms of Talata and making a decision just purely on this is a property and it needs to be sold. When there are children involved, different orders can be given, including actually postponing any sale of a property for a certain period of time.
That can happen under Schedule 1 of the Children Act, yeah.
Presumably based on the same principle as you outlined earlier, that the children's best interests are looked after.
Well, first consideration is given to the children. It's that the position of the children isn't the only consideration in such proceedings, but it's obviously a highly relevant matter.
Well, the spouse or the former partner who's no longer in the house can be locked in potentially there for a long period of time financially, and there's a certain unfairness there that can occur, right?
Yes. I think in what I'll call an everyday case, where you might be dealing with a 3-bed semi or 4-bed detached property, I think generally you would expect to see that property sold. But if there's a case where there is very significant wealth, and I actually dealt with such a case, it's reported anonymously, H versus C, which was a case where the husband was worth, I don't know, I think probably worth about 125 million, something like that. That's a case where courts are always looking to settle property on children. Now, that's not an everyday case. I think in an everyday case, if I can use that expression, you could expect to see the house sold.
So that people can get on with their lives.
Yeah, exactly.
Yeah, that is good to know. But the one thing we touched on prenups earlier, something that we would certainly encourage, because it does, when you are buying a house as an unmarried couple, the cohabitation or a deed of trust at that stage before you purchase the house it's a must-have, really, isn't
Absolutely
it?
Vital. Yeah.
Because it just will, the courts, again, provided it hasn't been entered into and there's any sort of coercion or anything along those lines, courts will enforce those
without
agreements.
doubt.
And it just...
People will be held to that, yeah.
And it just stops all of the... You can work out what's fair in terms of what the split should be in the equity in the property, perhaps based on the financial contribution. The one good thing is once they're married, typically, well, not typically, automatically those agreements, the cohabitation agreement will become null and void on marriage anyway. But certainly I know that our residential team is forever advising couples who aren't making an equal financial contribution to seriously consider entering into one of those agreements.
I'm pleased to hear it. It's very important.
No, it is very important. And on one level, what we want there to be is less disputes and for these things for our clients to proceed.
Yeah. I mean, you just mentioned there cohabitation agreements. Where people live together and they haven't got children, it's still a very good idea to enter into a living together agreement, just defining who's brought into what into the relationship, I should say, and what the arrangements are to be in terms of finances, who pays the mortgage, who pays for what. So even if there are no children and people want to live together without necessarily planning for children.
The cohabitation agreement is something that you would seriously get people to look at. It's sort of fixing the roof while the sun is shining, isn't it? And when there is goodwill between parties and they haven't fallen out, to have those discussions and then get that recorded in a document, which will then, it's almost like a present to your future self, isn't it?
I liken it to an insurance policy. Yeah. You hope it never sees the light of day because you'll live happily ever after. But, if you have to get the insurance policy out, well...
I'm thinking of sort of Homer Simpson, and there's one episode where he sort of, I don't know what, he's eating loads of donuts or drinking loads of beers, and he says, that's a problem for future me. Well, what you can do is with these sorts of documents, and yes, lawyers often will get involved, but you might be spending a small amount of money now to solve a problem for future me.
Well, we're straying into another area, but I mean, it's not unlike making a will.
No.
You want certainty, or you want as much certainty as you can gather. And that's what these agreements are about. And more, I mean, just getting back to the broader subject of agreements, there's case law which shows that judges will hold people to their agreements.
Oh, well, it makes sense. It does. Well, I mean, what we're always trying to do is to reach a final agreement promptly, keep the courts out of it, keep the lawyers out of it, and of course, keep the costs of these things as low as they possibly can be.
I wouldn't keep the lawyers out of it too much, because the agreements have got to be properly prepared.
No. I hear you, but in terms of much better, the money that you spend up front getting lawyers involved in amicable agreements is much smaller, much lower than the money that you will spend in a contentious 5-day trial, after 2 years of sort of legal wranglings. And I think that's...
exactly. And I mean, the quantification of stress going through that, 2 years, that's a pretty fair estimate. Although, is
that right? Yeah. Well, let's just touch upon that. A divorce proceeding. Let's go for an everyday divorce, and we have got, and it's a relatively regular family, albeit it's contentious.
I advise clients to write off the next 12 months to sorting out the balance of their lives. I think it takes 12 months. It can take less. But 12 months is about right.
Okay.
I mean, where proceedings are contested, just getting back to contested proceedings, one of the issues we have had is the court system is certainly creaking, and this does not add to stress. We've had cases listed for hearings, substantial hearings, which have been taken out of the list at the very last moment, the day before, because of
not enough judges.
Judicial unavailability, not enough judges. It's a problem. And of course, it not only does it add to the stress, it adds to the cost, because you do a lot of work leading up to that hearing. The case is relisted, and you've got to do
6 months later sometimes.
Yeah.
And I mean, again, in relation to that, trying to reach pre-agreements, prenups or cohabitation agreements will mean there's less things to dispute, but also participating in the mediation and taking those mediations seriously, so that it can be settled amicably at an early stage. And also, hopefully, what they'll get if they speak to us is a realistic both advice and in terms of a stance with our, we call them our opponents, but it's our colleagues at other law firms who are advising on the other side.
Yeah.
Because ultimately, you want to work to try and resolve the disputes.
You absolutely do. You absolutely do. I mean, I've been doing this work a long time, as you can tell. I'm over 21, and I know most of my counterparts. And although we don't have to be best mates, we don't have to be enemies, and we have to work towards a common goal, which is to resolve matters in a civilised and amicable manner. Of course, we can't always control the emotions and sins of our clients. We have to fall out, we have to fight, but first of all, we do try and deal with matters as you've described.
No, thank you. Well, thank you, Mike. Thank you for coming in today, and we will no doubt have you on again to discuss further developments in the family law arena.
I should be delighted to do so. Thank you.